Okay. Hello. Welcome to a short video on tenants' rights, brought to you by the Catholic Legal Assistance Ministry of St. Francis Community Service. This video will provide information on what rights you have as a tenant in Missouri, how to interact with your landlord, how to handle evictions and threats of eviction, and where to find resources and more information about your rights as a tenant. Let's get started by looking at just a few of the most important rights that tenants in Missouri have. Tenants have multiple rights in the tenant-landlord relationship, all of which can be found online from resources like Missouri government websites and the Missouri Attorney General's office. Here are a few examples. It starts with a lease agreement. A lease will likely not be in your favor, but a physical documented lease is the most important document you will encounter as a tenant. Tenants have the right to ask landlords to make changes or amendments to a lease before signing on. You should always make sure details are accounted for in the lease, like who will take care of the property, what the tenant is responsible for, etc. Landlords have the right to refuse any changes, but tenants do have the right to ask for them before signing for the first time. You'll want the lease agreement in writing and look out for any clauses about eviction, like the valid methods by which your landlord can serve you with an eviction lawsuit. You cannot be charged more than 2 months' worth of rent for a security deposit. The security deposit is kept by your landlord to use as a fund to repair any damage that you do to your rental. At the end of your lease agreement, your landlord should give you back your security deposit with an itemized list of reasons they are keeping any part of it for repairs. Make sure to demand a walkthrough before you move in which you would take videos and pictures of any pre-existing damage, so your landlord can't try and charge you for these when you move out. Tenants have the right to make their landlord pay for repairs to damage caused by normal wear and tear. If you need a repair made, make written requests and give a reasonable amount of time for it to occur. If conditions ever become unsafe or uninhabitable, tenants have the right to contact local housing and health authorities. If you want to withhold rent, you can place it in a separate bank account and write a detailed letter to your landlord explaining that rent will not be paid until the completion of all necessary repairs. Landlords do not have the right to discriminate against tenants based on race, sex, religion, disability, national origin, and other qualities when it comes to rent, housing availability, and subleasing availability. Now let's take a look at the best practices for interacting with landlords. The easiest way to avoid dealing with an eviction lawsuit is simply to be a good tenant. Generally, most landlords are reasonable and don't want to evict you without reason. By simply paying rent, following any rules, and explaining any situation to your landlord can likely help you avoid an eviction or any legal trouble that could compromise your housing. Even if you can't pay rent, the best thing to do may be to explain the situation to your landlord, including telling them when you'll be able to pay rent and remaining communicative throughout the process. Try and seek mediation wherever possible instead of going to court. We'll provide some links to mediators below. Even so, there are a few things to look out for. No person on your property, not just you, the tenant, but any person, should ever engage in criminal activity, drug-related criminal activity, make violent threats, or damage or threaten to damage property while in the vicinity of your tenement. These are all grounds for an expedited eviction. If your landlord comes to verbally demand rent from you that you haven't paid, it is in your best interest to pay the rent or explain why you cannot. A verbal demand for rent is often a precursor to a lawsuit. Written demands for rent are also generally a red flag. Now let's take a look at evictions and the threats of eviction. There are a few important things to know here and many rights that tenants have when it comes to evictions. Missouri is generally a pretty landlord-friendly state, but tenants still have parts of the law that protect them. Let's go through the basics. In Missouri, it's illegal for a landlord to try and evict you without court action. The landlord must have an eviction judgment entered by the court and enforced by the police. The landlord cannot try to evict you themselves by changing locks, removing doors, turning off utilities, or anything similar. If your landlord does any of these things without a court order, you can sue them for wrongful eviction, forcible entry and detainer, and can claim damages. When your landlord takes legal action against you, which they must to evict you, it will be in one of 4 methods. A rent and possession lawsuit can be filed against you if the only thing you did wrong is not pay rent. In this type of case, you have the right to pay and stay, meaning that if you just pay the rent and any late or legal fees, you can stay in your tenement. An unlawful detainer lawsuit can be filed if you violated your lease rental agreement in other ways, or are staying in your tenement past the expiration date of your lease. Next, an expedited eviction lawsuit is used against you in the case of drug possession, violent threats, property damage on your part. It's best to try to avoid these things. A contract action lawsuit is filed against you if you've abandoned or left your tenement, but left damages behind. The landlord is suing you for damages to the property, unpaid rent, or other violated parts of your previous rental contract. In conclusion, rent and possession, unlawful detainer, and expedited eviction cases proceed in the same manner initially. In all three lawsuits, you must be served with a suit at least 4 days before the court date. Make sure to attend this court date with any legal counsel you have. If you do not attend, a default judgment will be entered against you. If you attend and do not dispute the charges against you, a consent judgment will likely be entered into. But if you attend and dispute the charges, the case will be set for trial. Thank you. Please check out the links below for more resources on your rights as a tenant.